All right, thank you so much for your patience. Good afternoon. My name is Kaylee Hogan-Schnitker, and I'm the board secretary for the Lincoln-Lancaster County League of Women Voters. We are so glad to have you here today for our October Lunch and Learn to have a very timely conversation about voting rights. Before we begin, a couple housekeeping items. Please be sure that you're muted while our speaker is talking. We don't want any interruptions, and we want to be respectful of everyone's time and their voice. If you do have comments or questions, please utilize the chat function, and we will get to those at the end of our time. Again, we are recording this meeting, and we will send it out to you just in case you have to hop off early for some reason, and you're still interested in finishing up the topic. I will now hand the microphone on over to Terry Hendrickson, our committee chair, to introduce our speaker and program. Sorry, Terry, you are muted.
There, is that just a tad better?
Yes.
Okay, so again, welcome. I'm Terry Hendrickson. I chair our Lunch and Learn committee and our program series. We're glad that you've joined us for our program today titled Voting Rights, the Stepchildren of the U.S. Constitution. We meet the first Thursday of every month for important discussions, important topics that we think are going to be interested to lots of folks. And we believe that today's speaker and topic will be no exception. So without further ado, please let me introduce to you all our speaker today, John Gale. According to John, the U.S. Constitution, including the Bill of Rights, did not originally address the right to vote. It was only after the Civil War, 7 constitutional amendments, 5 major congressional laws, and many U.S. Supreme Court decisions before we were able to create a more fair and accessible voting system. John Gale served as Nebraska's Secretary of State from 2000 to 2018. He also served as Assistant U.S. Attorney, Minority Counsel to the U.S. Senate Judiciary Subcommittee on Constitutional Rights, Chair of the Nebraska State Advisory Committee to the U.S. Civil Rights Commission, and Chair of the Nebraska Republican Party. So without further ado, welcome and thank you for your presentation today, Mr. Gale. Please proceed.
Thank you, Terry. I also want to thank you and the League of Women Voters for your outstanding commitment to ensuring fair and equal voting rights for all citizens. I know the founding of the League of Women Voters probably came from the suffragette period of time in history and the battle for women's rights. So I want to thank you. I want to thank your organization for all the cooperation and help I received while Secretary of State on working on voting rights. Thank you. Well, we have a short period of time and there are a lot of things to cover. It's a complicated issue. So I'm going to skip through some history that's going to be relevant to the later part of my conversation. But let's start with the time following the Revolutionary War and the course of the Revolutionary War. Once the 13 colonies decided to seek their independence from Britain, they had to form some type of an organization so that these 13 independent colonies could cooperate together in securing their independence. And so they created the Articles of Confederation, which was the form of government from 1777 until 1788. And it was a very weak form of government because these 13 colonies had been independent. And now they're becoming states, and they have great jealousy of ensuring that they preserve their sovereignty and their independence to the greatest extent they can. And so the Articles of Confederation provided for a central government, but it had no executive branch. It had no court system. And in terms of voting, each of the 13 states had an equal vote. And for the most part, it took a unanimous vote in order for that central government to work. Obviously, it was not functional, but this issue of state sovereignty and states' rights was firmly embedded in that early period of history, and is something that we'll talk about later in my conversation, and how it's continued to be a part of the conflict between the federal central government and the state governments. Now, in the Constitution itself, it only provided one section dealing with election, and that was Article 1, Section 4, which in effect says that the time, places, and manner of electing US senators and members of Congress shall be decided by the state legislatures. But it goes on to say that the federal government can make or alter those regulations. Now, this is going to become another central issue later on in my discussion. During this period of time, from the beginning of the Constitution in 1789 until the Civil War, the focus seemed to be on growth. We had the ordinance of the Northwest Territory Ordinance in 1787, which was virtually the last act of the Confederation organization. And that was a piece of ground that was gained from Britain through the Revolutionary War. And that ordinance of 1787 provided that there would be no slavery in any states created in that territory. And so that also becomes a later issue, particularly for President Abraham Lincoln. So this focus on growth continued, of course, when President Jefferson purchased in 1803 the Louisiana Territory from France, over 800,000 square miles, unexplored, virtually unknown, but something that Jefferson felt was necessary to expand our growing nation. And this issue came back again in 1845 when Texas secured its own independence from Mexico. But the United States soon thereafter entered into a war with Mexico to secure the proper southern boundary. But as a result of that war, with the Mexican cessation, we gained over 500,000 more square miles, all the way from the Rio Grande to the Pacific Ocean. California wasn't yet a state at that time. And so expansion and growth seemed to be our focus. But one of the issues as we go through that growth, we had the Compromise of 1830, the Missouri Compromise. We had the Compromise of 1850. And for the most part, what we're dealing with is the issue of slavery. The North more and more was opposed to slavery. The South more and more was dedicated to preserving slavery. So in the course of those years, a new state couldn't come in as a free state unless there was an offsetting slave state. And the same, if there was a new slave state, there had to be an offsetting free state in order to maintain this delicate balance in the US Senate. Excuse me. I thought I'd turn that off. So we have an enormous issue through those years of how we're ultimately going to handle the issue of slavery. When the Compromise of 1850 was agreed upon, California became a free state, but there was a New Mexico territory and a Utah territory created. And the compromise was that popular sovereignty would decide whether the new states would be free states or slave states. The Kansas-Nebraska Act of 1854 was exactly the same. And these compromises were hugely difficult for the northern states because they so opposed slavery being extended beyond the original slave states. Now, when you think of the Declaration of Independence, when it states that we hold these truths to be self-evident, that all men are created equal, and we're dealing with the issue of slavery and the issue of equality, it finally comes to focus in the presidential election of 1860, when candidate Abraham Lincoln says, if I'm president, slavery can exist in the old slave states, but there'll be no slavery in any of the new states. And at the same time, the number of free states was down 19 and slave states were 15. So now free states have the greater number of votes in the Senate to proceed with whatever differences they might have on the issues of slavery. As a result of that, we had the Civil War. And in the course of that bitter war, Abraham Lincoln had to issue his Emancipation Proclamation in 1863, freeing slaves wherever his army would prevail. So following the Civil War, where the only action taken by Congress in the previous 100 years under Article 1, Section 4 was to declare a national election day. And that would be the first Tuesday after the first Monday, in order to eliminate the great disparity and differences of election days across the states. But that's the only step taken by Congress that had authority to address voting rights at any time under the Constitution. But because of that delicate balance, that was the only act of Congress. Following the Civil War, enormous progress was made on voting rights, because voting rights themselves, qualification of voting rights, was not addressed in the original Constitution, nor was it addressed in the Bill of Rights, which was the first set of amendments adopted in 1791. So we had a clean slate in terms of any progress being made on voting rights until the many constitutional amendments that finally began following the Civil War to establish voting rights, greater equality, greater fairness, greater liberty for the citizens of the United States. So of course, the 13th Amendment prohibited slavery. 14th Amendment extended citizenship to all those born or naturalized in the United States, which of course included the Black population. The 15th Amendment of 1870 provided the right to vote regardless of race, color, or previous condition of servitude. Now, these were enormous steps forward that could never have been achieved without the Civil War. The 17th Amendment then came along. The Constitution had provided many provisions where state legislatures had great power. One was the election of our president. It wasn't the people that decided by popular vote on a president. It was electors of each state. And the electors were chosen by the state legislature. In addition, in the original Constitution, the US senators were not chosen by popular vote. They were chosen by state legislatures. So you can see this adhering to state sovereignty, and the issue of state sovereignty continued up through even these constitutional amendments. But the 17th Amendment allowed for senators to be elected by popular vote, a big step forward to providing a more uniform system of popular election. The 19th Amendment, of course, provided voting rights to women after a 60-year battle by the suffragettes. The 24th Amendment in 1964 prohibited poll taxes on voting rights, which were used by a number of states, particularly southern states, to prevent the poor minorities from exercising their right to vote. Then we have the 26th Amendment in 1971, extending the right to vote to those 18 years of age. Is a very, very popular issue because of the Vietnam War and the concept of if you're old enough to fight, you're old enough to vote. And there was very little opposition to that. But I mean, it did extend voting rights to a young adult population who hadn't had it previously. And that left one group of occupants, residents in the United States, the Native Americans. So the Snyder Act of 1924 extended citizenship to the Native Americans within the boundaries of the United States. And by extending citizenship, it also granted the right to vote under the 15th Amendment. So for that period of time, following the Civil War until the early 1960s and 1970s, great progress was made through constitutional amendments. But constitutional amendments are not self-enforcing. They gave the right to be enforced to Congress. And so then it's a question, well, what did Congress accomplish? Well, the Snyder Act of 1924, but for the most part, this enhancement of voting rights that were not in the Constitution has come through constitutional amendment. So when does Congress decide it's going to enforce those constitutional rights? Well, this began in the 1964, when the Supreme Court issued their one man, one vote decision. And that really opened up a lot of opportunity for Congress to act to support that constitutional right. It was amazing to me in my lifetime. I graduated from law school in 1965. It was amazing to me while I was in law school and later in my career, how much was accomplished in such a short period of time by Congress. The Voting Rights Act of 1965, the Uniform and Overseas Citizens Absentee Voting Right, called UOCAVA, which ensured rights for hundreds of thousands of military and missionaries and business people abroad. The Americans with Disabilities Act, the National Voter Registration Act, which provided 3 secure methods of registering to vote that could not be annulled by state action. And that brought about 9 million additional registrations because of that act. So you had this whole series of congressional actions finally that was extending equality, accessibility, transparency to the system of voting. But probably the most important one was the Help America Vote Act of 2002, following that horrendous presidential election process in 2000. And that act provided money to all of the states to upgrade and improve their voting systems. It provided that all voting systems had to be tested and certified by the National Institute of Standards and Technology. And that gave far greater assurance to the states purchasing equipment that this equipment was safe, secure, and easy to have access by voters in order to cast a vote. So those acts, to me, really brought us to a pinnacle of achievement in assuring a modern, fair, secure, reliable election system across the United States. And I was very, very proud to be part of that and to implement that on behalf of the state of Nebraska. But at the same time, many states were also taking actions. For example, online voter registration started around 2010, In Arizona, by now, 44 states in the District of Columbus have online voter registration, which is now a fourth method to assure people of the right to register to vote. 19 states have election day voter registration, which we don't have in Nebraska. We filed the National Voter Registration Act, but 19 states provide the right to register on the day of election, which means that for people newly moved into the state, for people who have moved from one address to another, people who've reached the proper age, but within a short period of time, could all still register to vote in those states. 12 states adopted an election day to give people the opportunity from work to go and vote. It's not a high number, but still it's 25% of all of the states providing that. Early by mail voting grew phenomenally. It used to be by mail was strictly for those that had a cause or reason to be absent. But by mail became very, very popular. So we have 27 states that have early by mail voting. 8 states are totally by mail voting states, and 15 still provide strictly absentee voting. So to me, by the end of my last term as Secretary of State, I was so proud of Nebraska's election system and the election systems across the state, and how fair and accessible they were, with considerable federal support through funding and through certification of equipment. So I felt like we had finally overcome the mountains and the hills that had restricted voting rights in America. Well, that was before the 2020 presidential election. And because of the constant vocalization that that election was not fair, that the election was stolen in that presidential year, and there were so many methods to amplify that voice about stolen election, that we suddenly have a considerable number of citizens who don't think our voting system is fair or accurate. And it just seemed to me like this wonderful structure we had built is starting to crack and maybe not collapse, but to have considerable damage done as a result of that controversy. Despite the fact that 60 courts, federal and state, said there was no voting fraud across the nation that would affect the outcome of any elections in the states where those lawsuits were brought. But that alone still didn't give all of the citizens the reassurance that they wanted. So where are we at today? What are the pressing issues of popular unrest, of popular demand for something different? Well, first of all, the Democratic leadership in Congress in 2021 introduced an 800-page bill called For the People Act, which was going to standardize all phases of election across the nation. Now, that's coming under Article 1, Section 4, but it's the first time Congress has been maybe that insistent on a standardization of voting rights and voting systems. It passed in the House, made no progress in the Senate, and many critics of it, including New York Times, said it's way too much. It's too much to attempt. Cut that down into smaller bills. Go after the things that are critical, like the Electoral Count Act of 1887. Revise that. Revise the laws on redistricting. Pass a redistricting law, but don't try to cover every phase of elections. So that hasn't been accomplished, hasn't been attempted. And so that bill, HR 1 and S1, is simply dust in the dustbin at this point. But since that time, the Electoral Count Act of 1887 is finally in the process of being reformed. The House has already passed a bill that says that the vice president's role in presiding over the count is ceremonial. It says that each state can send only one certified set of electors. That bill says that a third of the House and a third of the Senate are necessary to object to trigger votes on the results. In other words, to challenge the state's electoral count. Right now, it's 1 and 1, a major change. Now, is there any chance of that passing in the Senate? Well, Minority Leader Mitch McConnell is very much in favor of it. And a bipartisan bill is working its way through the Senate. So I'm hopeful that that will pass, and that will be a very major achievement to give us all better assurance that it can't be repeated again, what we saw on January 6th, what we call the insurrection. In addition, an issue that bothers me and doesn't gain much public attention is that our Constitution provides there are 2 ways to amend the Constitution. One is Congress initiates a constitutional amendment, and it goes out to the states, which requires the vote of 3/4 of the states to approve that amendment. And that's how we've gotten the amendments that we have to our Constitution. The other method is a state constitutional convention that can be called by the states, independent of Congress. And there is a resolution that's been moving from state to state to state that would allow the creation of a state constitutional convention. But it will take 34 states to approve that resolution. And then whatever they come up with, it'll take 38 states or 3/4 to approve. Well, who sets the parameters on what's going to be looked at in that state constitutional convention? There aren't any. Congress doesn't have any. None are in the Constitution, which means that everybody can come to that convention with their own ideas and with their own proposals. And the popular ones are like a term limits for Congress, a balanced budget amendment, reduced power of the executive to issue executive orders, etc. Some of those sound like they might be good ideas, but a lot of bad ideas could come to that as well. Unfortunately, Nebraska is one of the 19 states that has signed on to that resolution. Now, it's going to take 34 states, so whether they get to that point or not, but that would be a very revolutionary time if such a convention is authorized. In addition, there are quite a number of election issues that have come up over the last elections, 2016, 2020. But the 2 things I want to talk about are voter ID laws and redistricting. Voter ID laws first came to public attention in 2008 when Indiana's voter ID law, the first one in the nation, came before the U.S. Supreme Court in Crawford versus Marion County Election Board. And there was considerable opposition to that by groups that filed briefs with the Supreme Court objecting to it as an act that would significantly suppress the vote from particularly minority and elderly populations in Indiana, and that it would be a major setback for voting rights. The proponents of it said, yes, but voter fraud is a great concern to the public. There was a great concern at that time about immigration and whether illegal immigrants might try to cast a vote. And the Supreme Court, in I thought, a highly unique decision, said, well, we find no evidence of voter fraud in Indiana. If this bill is attempting to address voter fraud, there's not an issue that needs a remedy. On the other hand, there's a strong public concern about voter fraud. And so we'll let this photo ID bill stand because it will relieve that concern of the public about voter fraud. And it will allow the state to take action against a potential injury by preserving the integrity of the voting system now, rather than waiting for voter fraud to occur. Now that's pretty subjective reasoning, in my opinion, but because of that, it really opened the door to a number of states to address voter ID. Now, you may or may not be aware, there's quite a difference in the kinds of voter ID that states have adopted. 8 states now have strict required photo ID. 8 states. 12 states have photo ID requested, meaning you're asked to produce it, but if you can't, you can sign an affidavit under possible perjury that you are one and the same citizen, or you can cast a provisional ballot, and that provisional ballot will be held until you show up no later than the count week with the proper identification. So there are remedies in the states that have photo ID requested. 3 states have non-photo ID requested, which could be a utility bill, it could be a rent receipt, it could be something that identifies the person with the address, which is really the whole issue when you're talking about impersonation, fraud by impersonation. So that makes it a lot easier for the citizens of those states to come up with a proper document when they go to vote. 13 states have non-photo ID requested. So now we're getting down to that same issue of, well, if you don't show up with it, you still have the right to file an affidavit or to show up with it later to confirm your provisional ballot. But non-photo ID is not the strict issue of photo ID, of specific kinds of photo ID. So this has amounted to 36 states that have some form of voter ID, supposedly addressing this issue of voter fraud, which the Supreme Court found in Indiana, it was virtually not an issue to be addressed. Well, how about the rest of the nation? Well, the Heritage Foundation, a highly respected conservative organization, studied voter fraud cases in the United States in the 21st century. That's from 2000 to 2020 in federal elections. They found 1,340 cases of voter fraud, for which there were 1,152 convictions out of 2 billion votes cast in federal elections during that period of time. I mean, it's so minuscule, it's so minimal, it's almost laughable that could become the basis for this extraordinary suite of voter ID laws across the nation. Maybe it does restore confidence in some members of the public, but we're not addressing a real issue. The Associated Press also reviewed the 6 battleground states in the 2020 election. they identified 475 cases of potential voter fraud in those 6 states out of 25 million votes cast. So again, it's infinitesimally small and doesn't affect the outcome of elections, but it's being passed nonetheless. And in Nebraska, it may be passed in this coming election because there is, of course, a petition initiative that puts it on our ballot. Now, 2 things that help resolve some of the public concern is that the federal courts have said, if you impose this on your public, and it's so significantly different from the way they've been voting for many decades, you have to have a public education plan. And in Tennessee, a state not a whole lot larger than Nebraska, it cost them $1 million for an appropriate public education plan. In addition, the state has to issue ID cards for those that don't have a driver's license, for example. And so that's a significant issue for people who are elderly or disabled, that they can be provided free of cost by the state with an ID card, a photo ID card. So you're going to have some costs. So in Nebraska, it could be $1 million for a public education plan. It could be $300,000 to pay for the state issued photo IDs. So there is a cost involved. It's not just requiring photo IDs, it's education as well. Well, the final issue that I want to talk about is an issue that's right before us in so many ways right now, including the Supreme Court. As I said, Article 1, Section 4 limits the scope of powers of Congress to act, except as to time, place, and manner of holding elections for senators and representatives. But it does say that Congress can either amend or act on its own part. But for the most part, this is giving the power to the state legislatures. And that, of course, includes the power for redistricting every 10 years after the US Census, when districts get redistributed. Even after the 2020 census, some states have lost a congressional district, others have gained a congressional district. So there's a reshuffling that goes on. In 2010, after the census, 59 districts shifted from one party to the other. In other words, some parties were able to gain seats and the other lost. There were 59 districts where the vote shifted. 20 of those were gains by Democrats. 39 of those were gains by Republicans. So it comes back to a question of who is doing the redistricting to ensure a fairness, a balance in each district, and is not providing absolute safe districts for the party of the legislature in that state. So that becomes a huge issue. Well, who controls the redistricting process across the country? 35 states, politicians control the process. And that includes 5 states that have redistricting commissions, but they allow political appointments so that it can be full of state legislators and call themselves an independent commission, but it's not a bipartisan or nonpartisan commission. So that's 35 states. Of the other 15, 8 indeed do have independent commissions. And so that's a start. And 7 states are one district states. They have one congressperson, and Obviously, redistricting is not an issue, but we haven't made great progress on redistricting with 35 states that allow the prevailing party of the legislature to determine the redistricting. So how do we address this issue? Well, the Supreme Court is a very significant party in redistricting. For many decades, federal courts as well as state Supreme Courts would get involved in partisan gerrymandering. When I say partisan gerrymandering, this is not racial gerrymandering, which is a different issue. This is partisan gerrymandering. And federal courts were quite willing to step in and require a new map, a new congressional map that would be more fair. But the US Supreme Court in 2019 in Ruckel versus Common Cause said, from now on, federal courts are not going to look at partisan gerrymandering issues. That is going to have to be dealt with by the state courts. Well, of course, that significantly eliminates one possibility of relief where citizens or League of Women Voters or some other group wants to claim that there's been abusive partisan redistricting. They're not going to be able to go to the federal court after that date. In addition, you have a state court system in which you have some judges in some states are elected, so they go up for election based upon the decisions that they're making. Others are appointed, some appointed for terms, some appointed for life. So you have quite a variety of state Supreme Court systems, but the US Supreme Court has said that we trust the state Supreme Courts to be the ultimate arbitrator of redistricting issues that come up through the state. So the Supreme Court's backed the federal courts out, allowing the state Supreme Courts to be the final voice. And the state Supreme Court has issued further decisions amplifying that point of view. Like in Wisconsin, the redistricting map was proposed by the governor, reviewed by the state Supreme Court, and approved. The Republican legislature went to the US Supreme Court and said they don't have the authority to do that. And the US Supreme Court said, yes, they do. This is a decision of the state Supreme Court. And the same issue came up for the redistricting of congressional districts in Wisconsin. Same issue, state Supreme Court viewed it and found the first maps to be discriminatory and approved the second map. And the US Supreme Court said, yes, state Supreme Court. So at this point, even though the federal courts are out of it, other than racial gerrymandering, federal courts still have sole authority over that issue under the Voting Rights Act of 1965. So it appears that rather than a kind of a uniform rule, the US Supreme Court could have in Ruckel versus Common Cause established guidelines and standards for the nation in terms of redistricting and what's an improper or abusive partisan redistricting, but they ducked it. And so now it's going to be up to the state Supreme Courts. But the Supreme Court also said, interestingly enough, if a state has an initiative petition to establish an independent, nonpartisan redistricting commission, that holds up under the Constitution too. It's not just the state legislature that makes that decision. The citizens, by popular sovereignty, can establish these commissions as well. Of course, Congress could do it if they passed an act requiring certain standards across the nation for redistricting. Congress has not tried to do that. And so it's interesting to see how many states might have initiative petitions to create a nonpartisan, independent redistricting commission as a result of all of the things that are happening as our nation gets further and further divided, because both sides, this is not just Republican, this is Democrat too, both sides are doing their best to establish safe seats for their party. And it's happening in Texas and Pennsylvania, Wisconsin, Florida, Georgia, Kansas. And those are Republican states, but it's also happening in New York and Oregon and Illinois and Washington. So it's happening on both sides, and probably they would end up with pretty much a balance and without many changes this time around, as opposed to 2010, except for another Supreme Court decision. Well, a federal court decision called Purcell. The Purcell case held that election rules and systems cannot be changed when it's too close to an election. That the old standards have to apply, even though there's attempts to create new standards. If it's too close to an election, they can't be considered. They can be considered later, but they cannot be considered if it's too close to an election. Well, in 5 states, in Florida, Ohio, Georgia, Alabama, Louisiana, this issue has come up because in each of those states, there has been a map that was very partisan, created, that got, of course, attacked for being so partisan. And a new map was required, and the state took its time devising a new enhanced plan. In one case, it was Governor Kemp in Georgia sat on the new plan until virtually before the primary election, so that the old standards applied. You had in Florida, the state Supreme Court, all 7 Republicans sat on review of the new reformed plan so long that a federal court said the old rules apply. So this Purcell case has complicated things because in those cases, racially gerrymandered cases, heavily partisan gerrymandered cases in those 5 states, the old rules apply. And as a result, there could be a change of anywhere from 7 to 10 Congress seats that would otherwise have been Democratic seats that are now saved by the Republicans in their states. And so that may create the imbalance in Congress following this election. We'll see how that works. But the third issue is in North Carolina, there's a Supreme Court case pending where the North Carolina Supreme Court ruled that the redistricting plan was adopted by the legislature was not impartial. It was heavily partisan. And the North Carolina Supreme Court ordered a new set of standards. And the legislature appealed this to the US Supreme Court and said, we want you to rule on that. Because under Article 1, Section 4 of the Constitution, it says that time, place, manner of election of congressmen and senators shall be determined by the state legislature. Now they're ignoring the caveat, but 4 of our Supreme Court justices have already said they're sympathetic to that argument. And so it's being argued in this session right now of the Supreme Court. A decision won't get made probably until next year, but it'll get made before the 2024 election of whether or not the state legislatures, independent of their governor, independent of their state Supreme Court. In other words, the total, absolute, arbitrary authority to decide on voting systems such as redistricting. So watch that. That's going to be one of the most critical Supreme Court decisions of this century. They call it the 800-pound gorilla in elections law. So that's something for us to keep an eye on, as well as these other issues I've talked about in terms of the state constitutional convention and voter ID laws across the nation and what impact they might have. So this is a kind of a general summary of some of the key issues that I wanted to talk with you about. I hope that you found it interesting. I hope it hasn't been too boring, but there's a lot to cover. But I think maybe if you think in terms of gerrymandering and voter ID and the power of the Supreme Court and the power of the state Supreme Courts, those are going to be key issues pretty much decided and addressed in this year. Thank you.
Yes, thank you, Mr. Gale. I have been enjoying every minute of this, learning lots, and we do want to have the opportunity to get to some questions. We have quite a few in the queue. But before we do, as we always do, I want to let you know about next month's Lunch and Learn. Our November 3rd topic is Schools 101, which will be presented by Rachel Gibson of League of Women Voters of Nebraska. She's going to be talking about the K-12 education system in Nebraska. So for those of you who join next month, you'll get an overview of that, as well as detailed information about 4 important topics: who attends our schools, students, who works in our schools, what pays for our schools, funding, and what guides our schools, our curriculum. Before we get to questions, and I'm just about there, I want to encourage everybody to travel on over to lincolnleague.org, our website, for at some point soon a recording of this program, as well as our previous Lunch and Learn programs. You can also find information there about membership in our league. So let's get to a few questions. We may be over a little bit from 1 o'clock. Those of you who are able to stay on, please do. Thanks again, Mr. Gale, for your generosity of time. Here's the first question that has been listed in the chat. This one from Linda Duckworth. I remember Neil Erickson saying same-day registration for Nebraska would be much more complicated and difficult than for other states because we have some unusual overlapping boundaries, NRDs, for instance. I'd like to hear your thoughts about that, and thank you.
I guess I don't quite see. Yeah, Neil was my deputy for elections, did a fantastic job. I great admiration for him. We worked together very well. But I'm not sure how registration is impacted by the distribution of boundaries amongst the various subdivisions. We do have a major problem because, I mean, it's not really a problem, it's a headache for the county election officials because we have so many races in Nebraska. There are so many political bodies that require elections. And so it's very difficult to try to ensure that precincts aren't split because of the great variety of elections with candidates. And we do end up with split precincts. And that's a real headache because it means that that precinct is going to have two sets of ballots because one portion of the precinct will have one race, another set of precinct will have another race. I forget the number of ballot splits that Neil used to talk about, but it's thousands. It's like 3,000 ballot splits because of the number of races that we have to include on our ballots. Does that answer the question?
I think it definitely does. Thank you much. And thank you, Linda, for the question. Our next question is from Peter Levitov. How do we overcome the situation reported today that a majority of the Republican candidates across the country, 299 in all, deny the results of the 2020 presidential election?
That's been a hard issue as a Republican to figure out. I'm a rhino, Republican in name only, I guess, because as a Secretary of State, a lot of these things are very troubling and offensive to me that are occurring. And of course, that's unbelievable, right? Unbelievable that a candidate for office would still believe that the election had been stolen. But I've noticed with several of the Republican candidates who have won in the primary and who had advocated that in the course of the primary, that the election had been stolen, suddenly, after the primary and they're the candidate, they changed their mind. And they no longer hold to that, adhere to that view. So it's politics, I guess, in many cases. They want to capture every possible vote in the primary, and there's going to be a percentage of Republicans in every primary who still believe that the election was stolen. And to capture that vote, they have to take that position. Now, is that honorable? Is that virtuous? Is that honest? Well, most of us would say no. In fact, it corrupts the system because they are feeding into the megaphone the fact that there's a belief that the election was stolen. So I guess we'll see. The other thing, Peter, that came up is that independent organizations and the Democratic Party put a lot of money into a number of those primaries for the benefit of those who advocated such extreme views. Why? Because if they could get them elected as a Republican candidate, it gives a Democratic candidate a much greater chance of winning in the general election. So there have been people who have contributed to that in order to get the weakest, most extreme candidate on the Republican side. That's the best I can share with you now.
All right, well, your remarks and thoughts on these things are interesting. I'm going to keep moving here. This question from Marta Nieves. What's going on with the Equal Rights Amendment? I understand that enough states have approved it. However, it needs to be voted to accept it. Would you please address this issue?
I have not investigated that particular issue. I remember over the years it had made significant progress in getting the 3/4 of states, but because it was slow progress, legislatures changed the political majority. And so the Equal Rights Amendment passed in a number of states. And then with the change of political majority, they revoked it. Now, can a state revoke? That's a hard question. For the most part, constitutional amendments have a time period in which states have to act. And it's customarily 3 years. But for the Equal Rights Amendment, apparently there was a time limit imposed. It really raises an interesting question whether those states that have revoked and have not renewed support affects the 3/4. It apparently does. I think from what you're saying is, by one count anyway, there's more than sufficient to go to Congress, and the Congress is failing to act on it. interesting question. I presume the question could be taken to the Supreme Court to force congressional action. But I think there's still a lot of gray area there because it's been so long a process.
Yeah. Thank you for that. I know this group has confidence that you can answer all kinds of questions and all sorts of topics, but here's another one. I think we'll close our questions at 1:05. Just wanted to let everybody know we're at 1:03 now. This question from Mary Lee Moulton. Isn't the Equal Protection Clause in contradiction to the article having states set election rules?
That's a very interesting question. That issue came up in the Supreme Court case dealing with the Bush-Gore election coming out of Florida. And the Bush lawyers were arguing equal protection in that Florida didn't have a state standard for how to count those punch card ballots. And without a state standard, each, I guess they call them provinces in Florida, each county may have had different standards. The state Supreme Court had ruled that there should be a recount. The federal Supreme Court said under the Equal Protection Act that the original count would stand. Still a controversial decision. I mean, here you have two constitutional provisions, one in an amendment and one in the original Constitution. And I think that they have to be interpreted to make them compatible. And so I would say probably the Equal Protection Clause is not going to overrule Article 1, Section 4 of the original Constitution. But you would think it would have some influence, however, in how courts decide these redistricting cases.
Very good. There are other questions. However, we have gone 5 minutes over our standard time, which is no surprise. This is a compelling topic. We have an expert in the field who's been sharing with us today. We are most grateful. I want to thank you again, John, for joining us and whittling this big topic down to some really good bites for us today. Thanks again to all who join us. Visit our website for more information, and we'll look forward to seeing you all next month. We are adjourned, and thanks.
Thank you, Terry. Thank you, everyone.